of 2012, and indeed the draft Legal Aid Sentencing and Punishment of Offenders Act 2012, amendment of Schedule 1 Order 2012. If I can discuss both, Sir Alan, but begin with the merits regulations. The Civil Legal Aid Merits Criteria regulations before us today set out the merits criteria both for applications within the scope of the Civil Legal Aid Scheme, which are described in Part 1 of Schedule 1 to the Act, and in relation to exceptional funding cases which fall outside that schedule. The merits criteria are those which the Director of Legal Aid casework must apply in deciding whether an individual qualifies for civil legal services. When the Director delegates his functions under the regulations to providers or his employees, they will also be required to apply these criteria. The criteria include both general merits criteria and specific merits criteria. Specific merits criteria are applied for particular types of case where the general criteria are considered to be too strict, or where bespoke criteria are appropriate for particular types of cases. These regulations replace the funding code created under Section 8 of the Access to Justice Act of 1999. The funding code criteria are based on a list of factors set out at Section 8 of the 1999 Act, which include the importance of the case to the client, the prospects of success, and the likely costs. Likewise, these regulations are based on a list of similar factors set out at Section 11, subsection 3 of the Legal Aid Sentencing and Punishment of Offenders Act. The criteria must also reflect the principle that in many disputes, mediation and other forms of dispute resolution are more appropriate than legal proceedings. Our intention in making these regulations has been broadly to retain the approach in the existing criteria. However, we do propose to make one significant change to the current funding code criteria, so that legal aid will be refused for any individual case which is suitable for a conditional fee agreement, or CFA. This is reflected in Regulation 39B of the regulations. At present, that funding code requirement is disapplied for judicial review, claims against public authorities, and claims for clinical negligence, and we have removed these exceptions. We believe that our limited resources should not be focused on cases where alternative options for funding exist. The Legal Services Commission, or Legal Aid Agency as it will become, has significant experience in determining whether a CFA is likely to be a real alternative. So Alan, I move on then to the Schedule 1 amendment order, and turning to that order, it makes legal aid available in relation to a review by the first tier tribunal where it has identified an error of law in its own decision on a welfare benefit appeal. It also brings into scope certain applications as required by the 2007 Hague Convention on the international recovery of child support and other forms of family maintenance, and addresses a technical issue in relation to legal aid for judicial review. So first, the order makes legal aid for advice and assistance available in relation to a review by the first tier tribunal where it had identified an error of law in its own decision on a welfare benefit appeal. This follows a commitment made by the government during Commons consideration of Lord's amendments of the Legal Aid Sentencing and Punishment of Offenders Bill to explore whether there was a way for independent verification to be used to identify those first-tier tribunal welfare appeals which involve a point of law. And we have given serious consideration to the options available for independent verification. However, imposing an additional task of verifying whether a case involved a point of law on the judiciary of the first-tier tribunal, the successor to the Legal Services Commission, or the Department of Works and Pensions proved unworkable and would have resulted in significant extra administrative and cost burdens. We do not consider it right to impose those burdens in the current economic climate. We have therefore decided on the approach set out in the order. The change set out in this order would impose no additional burden on the tribunal judiciary because they must already consider whether to conduct a review on receipt of an application for permission to appeal against a finding of the first-tier tribunal. The tribunal will conduct a review if it is satisfied that there has been an error of law in the first-tier tribunal's decision. I should point out that legal aid will not be limited to welfare benefit cases in this area only. The LASPO Act provides that legal aid will be available for advice and assistance for welfare benefit appeals on a point of law in the upper tribunal, including for applications made to the upper tribunal for permission to appeal. Legal aid will also be available for advice, assistance and representation for welfare benefit onward appeals in the Court of Appeal and Supreme Court. In addition, we have retained legal aid for welfare benefit judicial reviews and appeals which relate to a contravention of the Equality Act of 2010. Let me now turn to the second part of the order, which brings into scope certain applications to meet our international obligations under the 2007 Hague Convention, which we expect will come into force in April of next year. The Convention concerns the international recovery of child support and other forms of family maintenance. It sets out certain requirements for the provision of legal aid in relation to the recognition, enforcement or establishment of a decision in relation to maintenance, and these are reciprocal arrangements for signatory countries. The Convention is broadly equivalent to the EU maintenance regulations for which services are already made available under Schedule 1 to the LASPO Act. Yes, of course.
Minister, giving way on that point. These are obviously very complicated and often very stressful cases where a child has been taken out of this jurisdiction or maintenance is sought from somebody in another jurisdiction. Does legal aid extend to legal action taken in another jurisdiction by one of the aggrieved parents in this case?
Well, the position, as the Honourable Gentleman may have seen from the Act, is set out in, I think it is, paragraph 18 of Schedule 1, which sets out exactly what the parameters of legal aid that will be made available are. What we are doing with this order is adding to it to cover our obligations under the Hague Convention, which at the moment are not covered. So the answer to his question, I think he will find in section 18, but I'll be corrected if I'm wrong on the particular section number. But it is set out there exactly what is covered in terms of legal aid and what is not covered. What we do here is extend that to the Hague Convention obligations too, which will be of assistance, of course, to parents in the situation that he describes. May I move on then to the third part of the order before us, which addresses a technical issue in relation to legal aid for judicial review. In our consultation response, Sir Alan, to the legal aid reform proposals, we confirmed that legal aid would be available for judicial review subject to a few very specific exclusions. That remains our position, and it is reflected in paragraph 19 of Part 1 of Schedule 1 of the LASPO Act, which keeps legal aid for judicial review in scope in almost any area bar the exclusions debated and agreed by Parliament. However, an arguable effect of how LASPO is drafted is that judicial review may be in scope for any area of law listed in Schedule 1 despite the exclusions in paragraph 19. This order simply therefore makes a technical amendment to ensure that judicial review is governed exclusively through paragraph 19 and the specific exclusions have effect as intended. So, Sir Alan, I hope that that initial explanation has been of assistance to the committee and I look forward to the debate.
The question is that the committee has considered the draft Legal Aid Sentencing and Punishment of Offenders Act 2012, amendment of Schedule Order 1, Order 2012. Andy Slaughter.
Thank you, Sir Alan. It's a great pleasure to be here under your chairmanship once again this morning. The Minister has been very brief in his opening comments. I cannot promise to be as brief in responding, although he has asked me to finish in time for the Leveson statement, which I will endeavour to do. These are the first of what we expect to be a large number of regulations made under the Legal Aid Sentencing and Punishment of Offenders Act, as it now is. The background to that Act, which a number of members of this committee also sat on the committee stages of the bill, and is that it had a torrid passage through both houses, particularly through the other place, in which there were, I think, 11 defeats and 3 tied votes, which is something of a record. And at the time that the bill progressed, a number of concessions were made by the government, not sufficient. A number of those decisions by the other place were overturned in this House. but a number of promises were also made, some of them perhaps in extremis during the ping-pong stages of that, but promises nonetheless. And we could reopen some of the core arguments around LASPO. I suspect you wouldn't want us to do that today, Sir Alan, and I'm not intending to do that. In some of the briefings that we've had for this debate this morning, those issues have been raised. And I should perhaps say that, and I assume the Minister has also had the benefit of this, that I've had briefings from the Legal Aid Practitioners Group, the Young Legal Aid Lawyers, CAB, the Administrative Law Bar Association, Scope, Coram Children's Legal Centre, and indeed Liberty, and probably others as well. I mention that because I think it's quite unusual for there to be such a degree of concern among organisations when one is looking at statutory instruments, and I think that is the first alarm bell that there are problems with these SIs that need to be addressed. And I say at the beginning that we do not accept either of these sets of regulations as they are for some very good and serious reasons. But whereas in some of those briefings issues which are unresolved issues, the issue of what constitutes general advice, what constitutes law and what constitutes fact, the procedural issues, gateway issues, and indeed how specialist advice is to be funded at all, are all raised. I don't intend to take the committee's time with those issues this morning. I suspect that some of them, particularly the procedural issues, we will deal with when we consider future sets of regulations, and some of them will simply come out in the wash when we see how the inadequacies in the legislation as proposed works on the ground, and they may well be subject to legal challenge. But I think it's sufficient for today's purposes to look at what one might call broken promises, i.e. where the regulations as drafted are not in accordance either with the Act itself or in accordance with the promises that were given to Parliament when the Act was going through. But could I just make, before coming on to that, one other general point, which I'd ask the Minister to take on board for future committees in relation to LASPO, which is that we are expecting these regulations to come into force in the main on the 1st of April next year. I believe there's to be no consultation on any of the regulations. The widely held view in the professional community is that that's because if there were consultation, that would likely to be challenged by judicial review, and therefore the government prefers not to have no consultation at all. That there is to be no or very little guidance with these extremely complicated regulations, which are the largest change to legal aid since it was introduced in the 1940s. And we do not as yet have a programme for how many sets are going to be, how many of them are going to be affirmative or negative, and when we can expect them to come. So far, I know about 3 other sets of regulations which are in draft, which I believe are negative rather than affirmative, and have not yet been laid. The Minister may, when he responds later, wish to correct me on that. But what I would put in a plea is these are not all going to be contentious. Some of them are, some of them are not. But it doesn't help, I think, any members, including government members, if we do not have a clear programme about what is being proposed. The other issue in relation to the points I'm going to raise this morning is that I think I know what the government intends, and I do know why I oppose that. But there is a real lack of clarity, perhaps coming from that lack of guidance or consultation in relation to what are the most contentious points are. There are 1 or 2 points. I'll deal with the CFA point and also a point on public interest at the end, which I would simply like a response from Minister on. But I want to concentrate most of my remarks on 2 central issues, one in each set of regulations. One is in relation to changes in the availability of legal aid for judicial review, and the other is the issue that the Minister has addressed, which is the availability of legal aid for welfare benefits appeals. Of course, my colleagues may have other matters to raise as and when they speak. The connecting point with those two issues is that we certainly believe that what is proposed in these regulations is contrary to the clear assurances given to Parliament. There's a difference in the way that this was approached. There was quite extensive debate. There was a successful amendment in the House of Lords, which was partially then accepted by the government in relation to welfare benefits. And during the ping-pong stage in this House, there were very clear and quite lengthy assurances given by the then Justice Secretary. With judicial review, it was always the case, it was always the assumption that there would continue to be availability of legal aid for judicial review, much as exists at present, and that those assurances were given, and therefore there was not extensive debate on that because it wasn't believed to be an issue, but it does now appear, for reasons I'll explain, to be an issue. This is all set against a wider background of the Prime Minister's recent speech, in which he said he wished to severely curtail the availability of judicial review, and indeed recent statements by the Justice Secretary that he wished to go back and address legal aid with the idea of making additional savings. And so the fears which we have in relation to the promises being gone back on in the course of these regulations, and a more restrictive attitude taken both to welfare benefits and judicial review, seem to be borne out by the surrounding rhetoric of the government. Let me turn first of all to the issue of welfare benefits. If I can take the Minister, I know he wasn't the Minister at the time, to that debate on the 17th of April this year, in which the then Justice Secretary was responding to questions about how far there would be legal aid for welfare benefits appeals. And if I could just read into record the comments that he made then, so I can point out how there are odds with what is proposed here. He was asked by the member for Carl-Shorten and Wallington, can the Justice Secretary confirm that the government intends to ensure that all cases in which points of law are in contention, whether in the upper or lower tribunals, are funded through legal aid? If that's his intention, what will he put in place, either in the bill or in some other way, to ensure that happens? My honourable friend, Justice Secretary, says, anticipates the concession I was going to explain. What about the ones that involve legal issues? And I can conceive of a case in the lower tribunals in which what is raised really is a point of law. He wants me to find some equivalent to the upper tribunal, asking if there's some situation in which somebody, preferably the tribunal judge, certifies that the point of law involved where legal aid should be available. We do not have such a situation at the moment, and we will have to devise one. If there is no system for it, just as we have accepted the argument about legal issue in the upper tribunal, we will go away and work on that matter. The issue being that whereas the government was prepared to accept, to put forward an amendment at that stage, that on points of law, legal aid would be available in the upper tribunals and higher courts, they conceded the point as regards points of law in the first tier tribunal, but said that they needed more time to come up with a scheme. I have to say that members were not persuaded, and several members, the member for Diffid Meronit, who was a member of the committee, said this: surely if the point of law is a good one in the upper tribunal and all the way to the Supreme Court, it is equally good in the first tier, but if the case is unrepresented in the first tier, it is not going to go elsewhere. To which the Justice Secretary replied, I would like to see whether we can devise, with the help of the GWP, a system whereby we identify in the lower tribunals such issues that involve a legal issue. The further injection, which I won't read, but then the member for Cornwall, the very west part of Cornwall, includes the Isles of Scilly, I can't go any further than that. St Ives, I'm grateful for and came back to the point again. This is a point of real contention, perhaps the single most contentious point at this stage in proceedings. Does the Secretary of State's amendment exclude lower tier tribunals, or can it be interpreted in such a manner that lower tier tribunal appeals that are brought forward on the basis of evidence relating to the matter of law and then taken to an upper tier tribunal might be included without the need for further regulations? Justice Secretary, I have obviously failed to make myself completely clear, Precious thought, so we'll try again. As it stands, the government's amendment in lieu applies only to upper tribunals. The Right Honourable Member for Carshalton and Wallington and others argue that something similar should be available in lower tribunals in other cases. I've undertaken to explore whether we can find an alternative method of identifying those limited number of cases and getting them certified when they involve a legal principle. I cannot give a timescale, but we will move as rapidly as possible. Now, I was there for that debate. A number of members who here would have been there for that debate. It was principally Liberal Democrat members who were raising the point, but not exclusively, because this came from a Liberal Democrat amendment. It did not go in any way as far as we wish to go in retaining legal aid for welfare benefits, but it clearly was better than nothing. And what the government was at that stage conceding, i.e. legal aid for upper tribunals, was valuable but a very minor concession. And the logic that had struck even Liberal Democrat members was that if this was about law rather than fact, insofar as one can separate the two, that it should apply in the first tier tribunals as well. And I believe that every member who was there was clear that they had an assurance that the government was going to look at ensuring that where appeals went to the first tier tribunal, and the matter was a point of law, that legal aid would be available. Which brings us to the Minister's own written ministerial statement of the 18th of September, in which he says, candidly but not helpfully, while reiterating what he said he was going to do, to consider whether to extend legal aid for advice and assistance to welfare benefit cases in the first tier tribunal where these involved a point of law. Having considered the matter carefully, the government considers a system of independent verification is not feasible, but it will make available, subject to merits and means tests being satisfied, legal aid in the form of advice and assistance for those welfare benefits cases in the first tier tribunal, where the first tier tribunal has itself identified an error of law of its own decision. And then goes into set, as I set out in the current regulations, the two highly limited and specialised cases in which that will be available. And that, Sir Alan, is completely different from the assurances given by the government and the expectations that members of the House on all sides had of what was going to be proposed. In a nutshell, rather than legal aid being available for any matters which come before the first tier tribunal, which involve a point of law, and accepting there has to be a means of sorting the issues of law from issues of fact, it would be in those tiny minority of cases, and indeed how the view of many practitioners and indeed judges who sit on the first tier tribunals is that this could actually be no cases or a handful of cases in any 1 year, because the legal aid only becomes available ex post facto. It only becomes available after the appeal has been heard, and if at that stage the tribunal of its own volition decides that it has made an error of law. And I'll come on in a moment to the difference between error of law and point of law. I don't know if the Minister had an opportunity to see the very detailed briefing from the Citizens Advice Bureau on this issue. The first thing it does is it shoots the government's fox that it has proved impossible to come up with a scheme that would deal with this. Now, clearly, what the government should have done is simply concede the point and said that we will find a way in which, on matters of law, that legal aid will be available in the first tier tribunal. They've done the opposite of that. They confined it in such a narrow way that hardly any cases, if any cases at all, will become possible. In view of the Citizens Advice Bureau, the proposed scheme is irrational. The number of cases which go through a formal rehearing is very small, as the usual practice such issues to be dealt with by the second tier tribunal. In practice, advice on identifying a point of error in law will not be available before or during the tribunal's consideration of the case. They may be available afterwards, and the scheme only relates to errors of law rather than the broader points of law and statutory interpretation that may arise in first tier tribunal proceedings. They go through the same history as I've already been through in relation to this case. They agree that this is going to apply to a very small minority of cases. And of course, Citizens Life Bureau are perhaps the leading authority in relation to taking these appeals. They deal with tens, if not hundreds of thousands of welfare benefits cases a year. They also suggest an alternative approach, and their alternative approach includes these possibilities. Determination of a point of law by the tribunal judge or chair by way of an interim or interlocutory application procedure or a directions hearing at the start of the case. A certification process whereby applicants seek prior authority from the successor to the LSC, or introducing a scheme whereby agencies hold a contract for the remaining welfare benefits work, subject to audit by the LSC or successor body, that a case is within scope and involves a point of law. A competent advisor can distinguish between points of fact and points of law and would not waste time on applying for legal aid unless there was a genuine point of law, or risk the reclaim of legal aid payments under audits in the case, if the case were not within scope. That's a form of self-certification, which I'm sure the government is resistant to, but nevertheless it has sanctions in the sense that if the advisor is making the wrong decision, then the payments can be clawed back. But there are alternatives whereby the tribunal itself, or indeed the certification, the authorising authority, the DOLAC, would be able to make those decisions. Other than simply wanting to save money and to save time for itself, what is the objection that the government now has to adopting one of those forms of approach? It's simply disingenuous to say that there is not a way of doing this. Of course there is a way of doing this if the government wishes to. I'm conscious of the time, and I'm not going to spend a great deal of extra time in relation to that, but I would like a clear response from this point. Does he accept, first of all, that what he is doing is very materially different from what the House was promised during the ping-pong stages of the bill? And if so, what is the justification of that, other than that they have changed their mind? Is he prepared now to take these regulations away and look at that issue again? It's a point which was conceded by the government. This is not a point that's an issue. That where points of law are to be considered, and perhaps I'll deal very briefly with this issue of points of law and areas of law. I'd be interested to know what the Minister's own definition of areas of law is and how it differs from points of law. Certainly as far as the practitioners are concerned, areas of law is a considerably narrower point. It doesn't include. There are many issues, and this is a point made by the Honourable for Swindon South in the ping-pong stages. There are often areas of mixed fact and law. There are often areas which may appear to be matters of fact, but turn out to be matters of law. And again, there are a number of examples of that were given in the CAB briefing. Whereas an error of law is something far more narrow, where the tribunal has misdirected itself. And it seems to be another way of limiting the ambit of the regulation or the concession that the government has made. Can I move on? Sorry for the avoidance of doubt. What I'm speaking to, and that is the Legal Aid Sentencing and Punishment Offenders Act 2012 Amendment Schedule 1 Order 2012 and paragraph 3 of that order. Can I go on now look at the judicial review point, which is in the Civil Legal Aid Merit Criteria Regulations 2012. This is a point that is much easier to remedy, but the implications of which perhaps go rather further. I'm grateful for briefings on this, in particular from the Administrative Law Bar Association. I'm sure if the Minister hasn't already been briefed by them, then he will be shortly. The problem arises really around the single word reasonableness, or the omission of the word reasonable, from the regulation paragraph 53, which is on page 19. Now, it's clear that the government has thought about this, because this regulation has changed if the Minister is going to correct me and tell me that it's a simple omission, then I'm happy to say that. It may foreshorten proceedings considerably, but I don't believe it is, because there are changes from the first draft of this regulation. I'm just going to read paragraph 53. For the purposes of determination for legal representation in relation to a public law claim, the Director must be satisfied that the criteria in Regulation 39, standard criteria for determination for legal representation, are met, and that A, the act, omission or other matter complained of in the proposed proceedings appear to be susceptible to challenge, and B, the individual exhausted all administrative appeals and other alternative procedures which are available to challenge the act, omission or other matter before bringing a public law claim. Now, from the original draft, in little a, other matter replaces enactment. For some reason, the word has been removed. The individual has exhausted, now the individual exhausted. And the words which are available to challenge the act, omission or other matter have been added. What hasn't been added is the word reasonable, which appears extensively in other parts of the regulations in terms of qualifications for legal aid on public law matters. The definition of what constitutes a public law matter is given in paragraph 2, which is this: a public law claim means any matter which is described in any of the following paragraphs of Part 1 or Schedule 1 to the Act, Civil Legal Services: A, paragraph 19, judicial review; B, paragraph 20, habeas corpus; or C, paragraph 34, homelessness. That's important, and I'll come back to that in a moment. The standard criteria, which is a preliminary hurdle at paragraph 39, does indeed include the word reasonable. It says at little d, the individual has exhausted all reasonable alternatives for bringing proceedings, including any complaint system, ombudsman scheme or other form of alternative dispute resolution. And looking at legal persons, which is paragraph 75, again at 75 1 little b, the legal person has exhausted all reasonable alternatives to bringing proceedings, including any complaint system, ombudsman scheme or other form of alternative dispute resolution. And the proceedings are not likely to be allocated to small claims track. If those words apply to legal persons, and if they apply to the standard test, why do they not also apply to the standard criteria for determination of legal representation in relation to public law claims? That's the first question I'd like the Minister to answer. It may be, there is a contradiction here, but the advice that we've taken suggests that it will not at present be sufficient to rely on 39 or 75, or indeed that preferential treatment is being given to legal persons as opposed to individuals here. It simply means that at the end, as the regulations stand, 53 will be a bar in most cases to judicial review, and in all cases where there is some alternative remedy, whether it be a statutory appeal or whether it be any other form of remedy. And this is what has excited a great deal of interest. I can just say what the Administrative Law Bar Association says in relation to this. Draft Regulation 53 limits the circumstances in which legal aid can be made available for public law cases, judicial review, habeas corpus and homelessness cases. Its impact will be particularly damaging in urgent cases where to insist that claimants pursue all alternatives before resort to judicial review will leave them without a remedy when they most need it. If it is accepted, then the apparent effect is that the Director must refuse to grant legal aid where the claimant has not exhausted all administrative appeals and other alternative procedures which are available to challenge the Act, omission or other matter before bringing a public law claim. They recite, which I'm not going to do, the history of judicial review and the importance of it. Perhaps more importantly, they recite what the government has said from the consultation paper onwards in relation to preserving judicial review. The government's line has always been, although we've never accepted it, that for the most serious cases, where there is a threat to life or limb, that legal aid will be preserved. But they added, importantly to that, the issue of judicial review. In the consultation paper, they said, in our view, proceedings where the litigant is seeking to hold the state to account by judicial review are important because these cases are the means by which individual citizens can seek to check the exercise of executive power by appeal to the judiciary. These proceedings therefore represent a crucial way of ensuring that state power is exercised responsibly. By the time we'd got years rather than months later to the ping-pong stages of the bill, and indeed in exactly the same debate as I've quoted from extensively previously, the then Secretary of State said this: I can assure, this is in response to a point from the Honourable for Southwark and Old Bermondsey, or Old Southwark, I can assure him that we are continuing legal aid in all cases involving judicial review. So legal aid is available to someone who is trying to have a welfare decision judicially reviewed. That applies to every kind of judicial review, because we do not think the government or a public body should be resisting a claim about abuse of their powers from a litigant who cannot get legal advice. This is not an easy concession to make, because quite a lot of people who seek judicial review are not instantly popular with all sections of society, but we still give them legal aid. It's a pity that he didn't pass that message on to the Prime Minister before he made his speech 2 weeks ago, because the interpretation of the Municipal Bar Association is exactly the contrary of this. Whereas at the moment, the LSC funding code says that legal aid may be refused if there are administrative appeals or other procedures which should be pursued before proceedings are considered, which gives a power to decline funding if there's a suitable remedy available, but does not make it obligatory to do so. And that appeals not only to alternative remedies, but also to statutory appeals where judicial review may be a more satisfactory outcome. They go on to say that this is such a stark outcome that we doubt whether regulations, if passed in this form, would be lawful, and they would themselves be open to judicial review. And they make the point that I already made in relation to Regulation 39. The implication, if I'm right, if senior lawyers, some in the other place, some who are current practitioners, are right, and that the omission of the word reasonable or some other way of indicating that the status quo will prevail, it will be almost impossible for anyone to obtain judicial review, to obtain legal aid for judicial review under the system which the government is currently proposing. And that's the view also of the Legal Aid Practitioners Group. They say it will be virtually impossible for anyone to be granted legal aid for judicial review because the test is so restrictive, and they again suggest that the addition of the word reasonable is the most appropriate course of action to take. And I'm not going to pursue the point. There are a large number of examples that have been given. I mean, all that information is available to the Minister as it is to me. What I would like him to address today is that key central point as to what is the government's intention towards judicial review as regards legal aid. We know what its intention is towards a judicial review generally. It wishes to severely restrict that, and citing planning and development cases, but now it appears going on to include any type of judicial review, and we are awaiting the government's consultation paper in relation to that, but we are promised that the time in which cases are heard and the number of appeals may well be halved in that case. Now that will be severely restricted, but if in addition to that, the combination of those proposals with these proposals that will make it, even in urgent cases, very difficult to get legal aid for judicial review unless every other avenue has been exhausted. So whether that is a statutory appeal, or whether that is an ombudsman inquiry, an internal review by a body. That's why I come back again to Regulation 2. We were thinking about this primarily in terms of issues like planning, judicial reviews and so forth. This also includes habeas corpus. It could also include cases of detention. it also includes homelessness. Now, that raises the possibility that not only judicial reviews here, but statutory reviews, i.e. appeals against homelessness decisions to the county court, could be included. And I'd ask the Minister to clarify the position on that. All of these points could be remedied very, very simply and straightforward. I don't believe this is a drafting error, but I do believe it's a matter that the Minister needs to take away and think about. And if he's not prepared to do that, then there is not the possibility of us supporting these regulations today. Can I deal with two other points? One the Minister raised in relation to, and again it concerns Regulation 39, the point about CFAs. Well, without again reopening the whole debate about CFA, I think the Minister knows our views on that matter, that the changes which Part 2 of LASPO propose will very severely restrict the ability of meritorious claimants to obtain CFAs. Now, how does the Minister expect that this new and additional regulation will interact with Part 2 of the Act? And secondly, what is the process going to be? Having just rejected as overly bureaucratic and impossible to construct a process for determining welfare benefits appeals, whether it is a matter of law or whether it is a matter of fact, the Minister now believes that it's perfectly possible to determine whether a case can be subject to a CFA or should be legally aidable in relation to that matter. The point on public interest, if I just put the Minister to paragraph 6 of the merit regulations. Not something I say I spotted, but something spotted by a very senior practitioner, is this. What that says is, for the purposes of these regulations, a case is of significant wider public interest if the Director is satisfied the case is an appropriate case to realise real benefits to the public at large, other than those which normally flow from cases of the type in question. The existing requirement under the funding code says this. The case should be regarded as having wider public interest only if the Commission is satisfied that the case has the potential of proceedings to produce real benefits for individuals other than the client. Well, there's a stark difference between real benefit for the public at large and benefits for individuals for the client. And again, it seems to be a slightly backhanded attempt to limit the ability, to limit the public interest test. I simply raise that to ask whether that is the intention or whether that's against something that the government has not indeed noticed. So I think I'm going to conclude there. I would. It may be that I will need to be on the Minister, or I'll need to come back if at some point the points I've raised have not been answered. And I apologise for going on length. I apologise for raising a number of points there. But this is an unusual situation to be in with regulation, certainly in my experience, where what we are being presented with is diametrically opposed to what we expected in certain key areas and completely contrary to what was agreed and promised at the time that the primary legislation was going through this House.
Thank you, Sir Alan. I would like to restrict my comments mainly to the draft legal aid sentencing and punishment of offenders 2012 amendment to Schedule 1 order. Now, my honourable friends already referred to the somewhat stormy passage of the bill as it went through the two houses, and there was considerable opposition to the government's plan, I think it's fair to say, to exclude all welfare benefit matters from scope of legal aid. And that really wasn't awfully surprising. I mean, under the current system, legal aid annually funds around £20 million worth of services in the welfare benefit category of law at the legal help level. Now, under the bill as originally drafted, this whole category of publicly funded specialist legal advice is set to go, and that will have obvious consequences for the vulnerable people seeking advice and redress. And the members of both houses protested against the scale of this exclusion, and the result was, at the last hour, a government concession that would make legal aid and assistance available for welfare benefits appeal on a point of law in the upper tribunal, the Court of Appeal and the Supreme Court. And what we now have before us is the result of this and the fruit of this concession. But I have to say, I think there's clearly been a shift in thinking since the passing of the Act. There's a much narrower scenario. Legal aid is limited in those benefit cases, which, to quote the government, in the first-tier tribunal, where the first-tier tribunal has itself identified an error of law in its own decision. Now, this actually is completely inadequate, I'm afraid. It means that the government is no longer making any commitment at all to provide legal aid for people to prepare appeals to a first-tier tribunal, even where that appeal is on a point of law. Rather, it's only available where the first-tier tribunal has identified itself an error of law in its own decision. Now, presumably, where the tribunal has done this and identified an error of law and has set aside its own decision, legal aid might be available, and then only for the rehearing, i.e. drafting pleadings or making representation on legal points. So that means, if I'm correct in this, that means there's no provision at all for legal help to be available to a client to prepare a first-tier tribunal hearing on a point of law. Now, there are many more points of law arise under the Welfare Reform Act of 2012 that's coming in April. And many of these points of law will need to be tested. We can't have a new act coming in a vacuum of expertise. And it begs a number of questions. How many claimants does the Minister believe will actually have the knowledge and skills to identify an argument based on points of law and actually be able to put that argument to a tribunal in a coherent manner, let alone identify an error of law in the tribunal's decision? They talk about no additional burden on the judiciary. Well, it's placing an unsustainable burden on a client who is in a particularly vulnerable position.
I'm grateful to her and agree with every word she said. Didn't she agree, in addition to the burden it will place on the client, if the client's not able to pursue the case, it's actually going to displace that burden to other parts of the public purse, for example, health, education, child welfare and so on.
I totally agree with my honourable friend. That is exactly the point. And of course the DWP Select Committee identified in their latest report on universal credit that the need for advice will absolutely explode when the new Act comes into force. And since the first-tier tribunal can only identify an error of law in its own decision if a party requests the leave to appeal to the upper tribunal, what chance is there that any claimant is going to actually benefit from this provision unless they can access initial advice from a specialist welfare rights advisor? And these specialists have long practice in this area of law. They can identify points of law. And I know from my own experience how many people have benefited from this in the past when they brought in the supplementary benefit regulations. The Ministry of Justice claim that the additional legal aid provision may potentially reach 650 cases. But I would say that this is extremely unlikely in the circumstances. How has the Ministry of Justice arrived at that figure? My understanding is at the moment that these rehearings are exceedingly rare, as the usual recourse is to appeal directly to the upper tribunal. And in addition, I do believe that the government, have they actually confused points of law with errors in law, as this is what citizens advice believe? The majority of first-tier welfare benefits appeals turn on points of facts, such as financial or other circumstances or medical evidence, rather than technical points of law. But there are many that do raise significant legal issues over statutory interpretation. For example, social security regulations, legal tests for disability, whether someone is actually a carer in point of law, disputed application of case law precedents, etc. So can the Minister clarify whether there is some confusion over errors in law or points of law? So in the light of these concerns, I believe that the government should reconsider this order. There needs to be proper consultation with the tribunal by the judiciary, the advice sector, user groups need to take place as well. And a new order needs to ensure that claimants with legally complex welfare benefit problems will be able to access specialist legal advice, both at first tier and onwards appeal. Now, I mean, of course, the government could make a further undertaking to fund specialist welfare benefits advice by using its reserve powers under the LASPO Act. And the powers do allow it to extend the scope where necessary. And I mean, as we've already referred to, given the fact that advice on legal issues arising from the benefit reviews and appeals will ever become more important in the next few years because of the massive change to the system, I actually believe it's time to do that now.
Thank you, Sir Alan. Very briefly, because the points made by my friend, the member for Hammersmith and Fulham, cover a lot of concerns, and I think this is a very sad day that these regulations were brought before us, which go even further in restricting legal aid than is already based on legislation. My concern is that many of in fact all of the administrative errors that happen on benefit payments are the fault of the department itself, because they are the ones who administer it, so it clearly is their responsibility in the first place. And the onus is then placed on claimants to understand that procedure with no access to legal aid to make the initial complaint against it, and can only get legal aid at a much later stage if they've been able to mount the first objection. Well, we all represent constituents. We all represent constituents who are leading very difficult, very complicated lives, and many of them have no access to any advice or benefits whatsoever. I suggest any member concerned about this tries phoning their local CAB or law centre now and find out what the waiting time is just to get an appointment, to get advice. This isn't a criticism of the CAB or the law centres, this is just a fact of the life that many people face. And so restricting legal aid is yet a further hurdle placed in front of them. I get many constituents coming to me who've been overpaid tax credits. Mistakes happen, I understand that, and one would have hoped there would be a sense of reasonableness by the department about reclaiming those overpayments. Often there is not. Often there is immediate demands for very high levels of payments that are simply impossible for the family to meet because they had an income they believed they were entitled to. It wasn't their fault the department made a mistake, unless of course there's been deliberate deception in the completion of the form, which is a slightly different issue. And so I would ask the Minister to think again, reflect on the points made by my friend the member for Makerfield and the member for Hammersmith and the representations I know he's received from Liberty and other organisations on this. Legal aid is something that is absolutely crucial to access to justice for the poorest and most vulnerable people in this country. And if we restrict it and take it away, then we're effectively taking away justice from the people that most need it.
Thank you very much, Sir Alan. I'm grateful for the questions that have been asked, and I'll do my best to respond. Perhaps I can say initially, in response to the comments just made by the Honourable Gentleman, the member for Islington North, I think it is worth recognising in the context of this debate that although we are making changes to the legal aid regime, and not all of them will be to his liking, I understand that, we will still be retaining one of the most generous, if not the most generous, systems of legal support that is to be found anywhere in the world. And I think it is worth remembering that when we discuss these regulations. Now, turning to the points made by the Honourable Gentleman Member for Hammersmith, and he concentrated his remarks on the two subjects of welfare benefits and judicial review. So if I might take those in turn. In relation to welfare benefits first, he referred in some detail to the Hansard of the occasion during the passage of the LASPO Act, when a possible concession in relation to first-tier tribunals was discussed by the former Secretary of State. And it is clear from that Hansard, as one would expect, that what my right honourable friend was not doing was setting out a way in which this problem may be resolved, but rather undertaking to explore whether there was a way in which the problem could be resolved. As I set out at the beginning of this debate, we did look at ways in which we might resolve this problem, and we did not find a practical solution which would succeed in doing what the Honourable Gentleman asks us to do. But he is right that there, I think in fact it wasn't him, I think it was the Honourable Lady from Makerfield who made the point, that the majority of those cases which come to the first tier tribunal are not decided on points of law, they are decided on points of fact. And so in relation to the majority of the cases that the first tier tribunal deals with, the reforms we're discussing today will have no effect. But the difficulty that we face is with the certification of which cases are containing points of law prior to those cases being heard in the first tier tribunal. Now, the Honourable Gentleman for Hammersmith referred to the proposal made by the CAB for resolving this, and he asked me to respond to it. Well, as he said, there were three potential ways of doing this identified by the CAB. Either that we could have a separate hearing, or that the LSC or its successor could deal with the problem, or that we could have a system of self-certification. Give way.
For the audience, there was a fourth way suggested by the CAB, which was that the DWP could identify the cases. I didn't even bother with that one.
Well, I'm grateful to the Honourable Gentleman, and I know why he didn't bother with that one, because that would be ridiculously expensive. And I'm afraid that the difficulty is in relation to all three of the remaining options put forward by the CAB, all of which, as he would expect, the department has looked at as potential ways forward. They all have very serious problems. If you pursue the option of a separate hearing, or indeed if you ask the LSC or its successor body to do this instead, you do incur considerable additional cost and administration, and that simply isn't feasible. And in relation to self-certification, he said himself, the government is understandably reluctant to pursue a course of action which would involve self-certification. So it isn't, I'm afraid, the case that the government has failed to notice the CAB have come up with a solution to this problem. We have explored the options that he has identified and which they have identified. I'm afraid they simply are not practical. Give way again.
I'm very grateful for your time, but I hope he does understand on this side. This is a key point. Could you say a little bit more about the first option, which is an interlocutory application to the tribunal chair? Effectively, this is saying to the chair of the tribunal, you need to make a decision on whether this go forward. The real dividing line between us is whether, on those issues which are points of law, that legal help is going to be available for the tribunals, or whether it's going to be on this absolute exception, this nugatory basis, and that is what was pointed. I'm looking at the Liberal Democrat members when I say this, because this was the point which particularly was the point for them. It was the point which we accepted as an adequate second best what we wanted, and it's just not good enough for the minister. I mean, it's been very fair in his statement saying they weren't going to do it. He's perfectly clear in that. But does he understand why that's not good enough? It's not good enough to say this is what we intend to do, and then we're not going to do it.
Minister.
Well, as I've tried to explain to the Honourable Gentleman, I don't accept that that is what we said. And the Hansard that he read out to us didn't give that undertaking. What it gave was an undertaking to look into ways in which this issue may be resolved. That is precisely what the government has done. But for the reasons I'm explaining, there isn't a way forward as easy as he would have us believe. And in relation to his specific point about a separate hearing or an additional hearing, there are 400,000 cases or thereabouts that come to the first tier tribunal. Is what he's suggesting that we should have an additional hearing 400,000 times a year? And if he is, it'd be very interesting to understand exactly how he proposes to pay for that. In fact, of course, it would be very interesting to understand in more general terms what cuts to legal aid his side of the committee and his side of the House propose, because they have indicated, as we know, that there would be some cuts to legal aid under a Labour government, but mysteriously they are unwilling ever to give us any details. And I'm happy to give one.
I'm very happy to respond to that, because we were very clear. I'm not going to rehearse with you. Over Huntington is here. The very long, protracted discussions we had about funding, where money was coming from. That's a red herring here, because the government said it intended to do this. It did. I'm sorry, the minister is absolutely wrong in that. He said he intended to do this, and the idea that interlocutory hearings are suddenly some great new beast in the system. Interlocutory hearings exist in many tribunals, employment tribunals being a good example. They're often there to save money because they resolve issues at an earlier stages which unrepresented or partially represented litigants need assistance from the tribunal for. I can't see why he's so resistant to it.
Minister.
Well, I'm resistant to it because, as we've discussed and as I think across the committee we've agreed, it is a minority of cases at the lower tier tribunal where a point of law would be at issue, potentially a very small minority, but the interlocutory hearings he's describing would be required in all hearings at the lower tier tribunal, all 400,000 of them. And that's why I resist the idea, I'm afraid. But let me see if I can turn to what I think is the substance of his concern. It's understandable. Of course.
This is extremely interesting to be on this committee for those of us who went through the original bill committee. And can I just confirm for my own benefit what the Minister's saying? Is he saying that the point made by the former Secretary of State as this bill went through the Commons, that it would be available for points of law in first-tier tribunals, that he believes this meets that criteria, or that that promise given no longer applies, that it's simply not been possible to deliver on that?
It's neither of those, I'm afraid. I don't accept that that's the promise that was given. What my right honourable friend, the former Secretary of State, said was that he undertook, quite properly, to look at whether there was a way of resolving this problem. Now, what the government is proposing, incorporated in these regulations, is the solution that we have come up with. I entirely accept that it is not to the liking of honourable members opposite, and they would wish us to do more. And of course there are many areas in which this government would wish to do more, but sadly the golden economic legacy that his party did not leave us with restricts our freedom of action somewhat. And it simply isn't adequate, I'm afraid, for the opposite party to continue to ask us to spend more government money when they didn't leave us any. But let me come to the substance of what I think the honourable member for Hammersmith is talking about, which is whether or not these changes would leave a situation in which those who do have a point of law that they wish to litigate without a remedy. Now, I think it may be helpful to look in some detail at the process through which these welfare benefits cases go. The first thing that happens is that a decision is made. If the person on the receiving end of that decision doesn't like it, the first thing they can do, of course, is to ask the DWP to reconsider that decision. If the refusal is maintained, they can then appeal to the first tier tribunal. It is perfectly right that legal aid is not available for that process. But as I think the Honourable Gentleman for Hammersmith and indeed the Honourable Lady from Makerfield from her experience know very well, the purpose of the tribunal system is to enable cases to be heard without the need for lawyers, for simple language to be used and for people to be able to engage with that process without the intervention of counsel or of other representation. So that is the first thing that happens. What then happens is that the first tier tribunal reaches a conclusion, and the person will then receive a statement of the reasons for that first tier tribunal decision. That statement of reasons they can then read and decide what they wish to do next. If they decide that they wish to submit a request for that decision to be appealed to the upper tribunal, then of course the first tier tribunal has to consider that request. When they consider that request, they have three options. They can either review their own decision, or if they decide to not review that decision, the next step will be to decide whether to grant permission for a further appeal or refuse that permission. If the tribunal decides to review its own decision based on its perception of an error of law on its own part, then legal aid will be available for submissions to be made about that review. If, on the other hand, the tribunal decides not to review, and as I say, the next step is to decide whether or not to grant permission for a further appeal, if the decision is made by the lower tier tribunal to grant an appeal to the upper tier tribunal, legal aid will be available to the individual for that upper tier tribunal appeal. If, on the other hand, they decide to refuse permission for that further appeal, then, of course, the individual can appeal direct to the upper tier tribunal when, again, legal aid will be available. So if someone has a point of law to litigate, it seems to me that there will be an opportunity for them to do so with the benefit of legal aid in the upper tier tribunal. So I have to say, in relation to the Honourable Gentleman's contention, that the situation we're creating here is one where no one who has a point of law will be able to litigate it because of the way we've restricted access to legal aid at the lower tier tribunal isn't realistic. But I give way to
I think the Mayor should go, when Hansard is published, go back and read the last few paragraphs he's just said and see just how opaque the system he is setting up is, and how difficult it is going to be, impossible it is going to be for most litigants in person to deal with. I suspect that that is the government's objective. I've got it now that the government is not going to do what it said it would do. I'm comforted. I'm buoyed by the fact that the Peer of the Year has joined us, and the architect of the Peer of the Year on the basis of his the architect of the 11 defeats of the LASPO beer in the house in the other place. And I'm also buoyed by the fact that I've done a quick head count that I don't imagine the Liberal Democrat members are in any way satisfied that he has met their requirements, and therefore I think we've got a majority of one.
Minister.
Lost the argument.
I look forward to the vote as much as the honourable gentleman does. And he used to make similar confident predictions, I recall, throughout the LASPO committee stage, and was invariably wrong. However, let me try and simplify what I'm saying for you. It seems to me that when someone gets the result of a lower tier tribunal, there are 3 ways they can go. In each of those 3 ways, legal aid will be available to them. Now, in that circumstance, I really don't think that the honourable gentleman's point holds much water. Can I also say in relation to the honourable lady from Makerfield, it is right that this concession, as I say, is limited, and necessarily so for the reasons I've explained. But again, it would be wrong to assume that this is the only concession the government has made in this area throughout the course of the LASPO Act. She knows perfectly well that yes, indeed, we began with the view that no legal aid should be available for welfare benefit cases, but legal aid is now to be made available for points of law in the upper tier tribunals, which is where, of course, points of law are properly to be litigated. So, let me move on, if I may, to the issue of judicial review, where the honourable gentleman for Hammersmith made his remaining remarks. He's expressed some concern about the rhetoric the government has used around judicial review. I'd simply say to him this, that when one looks at the figures for judicial review, they are instructive. That in 1998 there were 4,500 cases brought for judicial review. In 2011 there were 11,000, more than twice as many. Now I'm sure that the Honourable Member for Hammersmith would like us to believe that the reason for that is that public bodies, and specifically government, makes twice as many bad decisions in 2011 than it does in 1998. But I'm afraid the government isn't convinced that's the reason. And so we do need to have a look at the way in which judicial review is operating. But none of that is actually the content of these particular orders. What he's really concerned about here is whether or not we are unduly restrictive about legal aid for judicial review if we do not include the word reasonable in paragraph 53 of the legal aid merits criteria. And he asked me a couple of specific points which I will try and deal with. The first is in relation to the contrast between the language of paragraph 39 and the language of paragraph 53. And he's right that there is a difference. But it's important to note that in relation to paragraph 39, what is required here is that the individual does not have access to other potential sources of funding from which it would be reasonable to fund the case. But that the individual has exhausted all reasonable alternatives, and again he used the word reasonable, which he draws attention to bringing proceedings, including any complaint system, ombudsman scheme, or other form of alternative dispute resolution. The difference, of course, in paragraph 53 is that we are predominantly talking about court proceedings. And in relation to those court proceedings, the simple view of the government, and this must be right, is that if there are court proceedings available to someone to pursue instead of judicial review, then that is precisely what they should do. In relation to paragraph 39, we are talking about other procedures outside court proceedings, and in those cases, it would not always be reasonable to expect someone to pursue those alternative proceedings. That's the difference. I give one.
I'm sorry, but these are very important points. First of all, it is not clear at all from the drafting of paragraph 53 that it only applies to statutory appeals. If that's the Minister's intention, then it is defective drafting. And secondly, as I indicated quite clearly, and I didn't go on at length about this point, but I could give him examples if he wanted to, that it is not always the case that a statutory appeal should take precedence over judicial review. Yes, it may well be, under the current funding code, that a decision will be taken that judicial review is not an appropriate remedy which merits public funding because there are alternatives, but that isn't the case. It may be because the language that's used at the moment is where an alternative procedure is satisfactory, suitable, or equally effective or convenient. It may be too slow, it may be not an effective remedy, it may be not such an all-encompassing remedy, it may not have the same types of remedy, e.g. injunctive relief, as a judicial review would have. And that's a matter of discretion, the decision. It's not anymore. And so I think the Minister's wrong on both points. Firstly, it doesn't, that 53 does not, as currently drafted, only appeal to statutory appeals. And secondly, even if it does, there may be circumstances, even if they are not common, where a judicial review is appropriate before all statutory appeals have been exhausted.
Right. Let's take those in turn. First of all, I didn't say that paragraph 53 only referred to statutory appeals. I said it referred to court proceedings. And there's a difference between proceedings and other processes which are described in paragraph 39. Secondly, he's wrong also, I'm afraid, that there is no discretion here. What paragraph 53b says is that the individual exhausted all administrative appeals and other alternative procedures which are available to challenge the act, omission or other matter. The interpretation, therefore, of availability to challenge an act, omission or other matter is what is significant here. If it is the case that someone does not have access to a remedy which would challenge the act, omission or other matter, then of course legal aid would remain available. What is being said here is that if there are other measures available to challenge the act, omission or other matter, then they should be used, particularly where they are court proceedings. And that is the position that is set out. There is a degree of discretion because, of course, whoever is making this particular funding decision would have to determine whether or not there were other measures available to challenge the act, omission or other matter. Of course, I give way.
Dan Rogers.
Very quickly, giving way. An issue perhaps of concern here as well is not just the availability of such mechanisms, but also their effectiveness in terms of timescales and so on. As constituency MPs, we come across cases with various public authorities where an appeal to somebody has dragged on for a very long period of time, and people understandably get frustrated while they're being disadvantaged in the meantime. So is that an issue that's been considered?
Yes, I'm going to one of my friends, and he makes a good point. And in relation to that, I think again, if a measure, another remedy, is only available too late, then I think we can expect that the guidance would make it clear that that is not therefore an available remedy. So the remedy that would be available alternative to judicial review would have to be one that took effect within the required timescale. So I think I can help him with that, and I think that's what guidance should make clear. What we're talking about here is a measure that is available as an alternative, which would, as the paragraph says, be available to challenge the act, omission or other matter. If something wouldn't be available in time to do that, then I don't believe it would qualify, and I would expect guidance to make that clear. Yes.
Well, I'm grateful. I think I'm grateful for his clarification, if that's what it is, that are available to challenge the act, omission or other matter refers exclusively to court processes, and therefore internal reviews, ombudsman's reviews, other types of challenge would be excluded from that, because that certainly wasn't my reading of that. And if he wishes to confirm that, then so be it. I'll have another point, but if he wants to. Minister.
Well, the distinction that I've made is between what is set out in paragraph 39 and what is set out in paragraph 53. What's set out in paragraph 39 are clearly not court processes. They are alternative procedures which do not take place in court. There is a difference, therefore, between bringing legal proceedings and pursuing non-legal proceedings, which is what is set out in paragraph 39. It's also, incidentally, what's included in relation to legal persons under paragraph 75. So those two things are the same, paragraph 39 and paragraph 75. There is a difference in paragraph 53, because what we're talking about here is legal proceedings. And where there are better and more efficacious legal proceedings, and where those should be relied on, then legal aid would not be available for judicial review instead. I don't know if that helps.
I'm struggling, however, still with the point on discretion here. Firstly, what has the Minister got against inserting or reinserting the word reasonable there, which would seem to clarify this without what the Minister said, which is his interpretation in relation to timing. He's mentioned guidance. Could he clarify, is there going to be guidance specifically on this, or on these regulations generally at some point, which will clear up some of these points? But does he accept that the intention of the government here, as it is elsewhere, is to restrict access to judicial review?
Well, the position on restricting access to judicial review is set out in paragraph 19 of Schedule 1 of the LASPO Act, and that's very clear. And we've discussed elsewhere in this debate that we want to make it very clear that that is the nature of the restriction that we wish to apply to access to legal aid for judicial review. There will be guidance in relation to paragraph 53, and what I am saying to him, and indeed to my honourable friend for North Cornwall, I think, yes, North Cornwall, is that in relation to timing, where we are dealing with urgent cases, this is an area that I think guidance can very helpfully deal with and offer the reassurance that both he and the honourable gentleman would like to see. But let me finally, Sir Alan, turn to another matter, which is CFAs, and these were the last points that the honourable gentleman made in relation to CFAs. I understand, of course, that he has reservations about CFAs. I spent many happy hours listening to his reservations during the committee stage. We're not going to go through all of those again. But the government's position is very clear, which is that if a case is suitable for a CFA, then it should not also be eligible for legal aid. Where it is not suitable for a CFA, then, so long as the other criteria are met, legal aid will still be available. That's the government's position. And I go back to what I said a little earlier on, Sir Alan, in closing, that when we look at the situation we face in dealing with the legal aid budget, we cannot discount the economic circumstances in which this country finds itself. And I'm afraid it simply won't do for us to have argument after argument about the legal aid budget, where the opposition continue to pretend that there is a lot of money available. We all remember that we were not left a golden economic legacy by then. We were left a note that said, sorry, there's no more money, and a mountain of debt. And on that basis, we do the best with what we have. I submit that what we have here is a sensible approach to the legal aid budget, a sensible approach to the criteria and merits that we need to set, and I invite the committee to approve the orders before us.
The question is that the committee has considered the draft Legal Aid Sentencing and Punishment of Offenders Act 2012, amendment of Schedule 1, Order 2012. As many as that opinion say aye. Aye. Of the contrary, no.
Aye.
Aye. Division.
Aye.
Lock the doors. Lock the door.
Paul Burstow. Aye. Jeremy Corbyn. No. Tracy Crouch.
Aye.
Mr Ginobili.
Aye.
Bill Esterson.
No.
Mr Evanet.
Aye.
Yvonne Fauvard.
No.
Kate Green. Chris Heaton-Harris.
Aye.
Stephen McPartland.
Aye.
Mr Meacher.
No.
Caroline Noakes.
Aye.
Jonathan Reynolds.
No.
Dan Rogerson.
Aye.
Mr Scott.
Aye.
Mr Slaughter. No. Jeremy Wright.
Aye.
The ayes were 10, the noes were 7, so the ayes have it unlocked.
Draft Civil Legal Aid Merits Criteria Regulations 2012.
I call the Minister to move formally.
Formally.
The question is that the committee has considered the draft Civil Legal Aid Merits Criteria Regulation 2012. As many as though that opinion say aye.
Aye.
The contrary, no.
No.
Division. the doors.
Paul Burstow.
Aye.
Jeremy Corbyn.
No.
Tracy Crouch.
Aye.
Mr Ginogly. Bill Esterson.
No.
Mr Eminent.
Aye.
Yvonne Favarg.
No.
Kate Green.
No.
Chris Heaton-Harris.
Aye.
Stephen McPartland.
Aye.
Mr Meacher.
No.
Caroline Noakes.
Aye.
Jonathan Reynolds.
No.
Dan Rodderson. Mr Scott.
Aye.
Mr Slaughter.
No.
Jeremy Wright.
Aye.
The ayes were 10, the noes were 7, so the ayes have it. Unlocked. Order.